Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 3 and 4 on the speed of 90 words per minute. Start. In our considered opinion, it is the duty of the Commission to award marks on the basis of a correct key answer. When large number of candidates appear at an examination for seeking appointments and the selection is very competitive, even one wrong answer to a question can alter the fate of many candidates. The petitioner may be entitled to appear at the main examination if he gets 301 marks because the answer to one question is correct but the commission has marked it wrong. There may be number of candidates who could have appeared in the main examination because of the correct answer given by them to question number 52, but which has been found to be incorrect by the commission. We are conscious that the main examination has already been held and interviews are going on, but it is also a fact that the final result has not been prepared. It would be wholly unjust to deprive such candidates who could not appear at the main examination for this reason. The purity in the selection process has to be maintained. The mistake committed by the commission has to be rectified and the candidates who appeared at the preliminary examination cannot be made to suffer because of the mistake of the commission. Such a course is being adopted as at present appointment orders have not been issued and only interviews are being conducted on the basis of the marks of candidates who had appeared at the main examination and the criteria determined by the commission. In such circumstances, it is considered appropriate to direct that relief should not be confined to the petitioner alone, but to all the candidates who had appeared at the preliminary examination. The court may have taken a different view in restricting the relief to the petitioner alone if appointments had been offered after the interviews and such persons had worked for some period of time. If any mistake can be corrected before the appointment is made, it should be corrected because candidates should not be made to suffer on account of such discrepancy. In Rajesh Kumar Supra, the Supreme Court pointed out that the High Court was justified in molding the relief prayed for and issuing directions considered necessary not only to maintain the purity of the selection process but to also ensure that no candidate earned an undeserved advantage over others by applicable of an erroneous key. It also needs to be noted that only a very limited number of candidates will be disturbed. Each question of general knowledge paper is of 1 mark only and only answers to 2 questions, one in this petition, and other in the connected petition bearing writ petition number 58554 of 2015, which has also been decided by order of date, have been found to be incorrect. It would, therefore, be just and proper for the court to direct the Commission to determine the marks of all the candidates who had appeared at the preliminary examination on the basis of the correct answer to question number 52 of the general knowledge paper. Learned counsel for the petitioners has primarily emphasized that learned prescribed authority while rejecting the application moved by the petitioners for cross examination of the witnesses produced by the plaintiffs has erred in law. He has also stated that while rejecting the application seeking permission to cross examine the witnesses, the learned prescribed authority has not assigned any plausible reason therefor. His further submission is that a specific ground was taken by the petitioners by filing appeal before the appellate court against the order dated 22/12/2012 passed by the prescribed authority. That learned prescribed authority has wrongly rejected the application seeking opportunity to cross examine the witnesses, but learned appellate court has also not considered the said prayer in its correct legal perspective. In this regard, he has submitted that application made by the petitioners before the appellate court was rejected on 22/11/2014 with the observation that the issue will be considered by the appellate court at the time of final hearing of the matter. However, while rendering the final judgment, the appellate court has not considered the said prayer and has also not taken into account the ground raised by the petitioners related thereto by observing that the application made by the petitioners stood rejected earlier, and as such there is no justification in considering the said application. Apart from the aforesaid ground of denial of opportunity to cross examine the witnesses, learned counsel for the petitioners has also stated that, in fact, the findings of fact recorded by the learned prescribed authority, which has been affirmed by the appellate court in respect of bona fide need and comparative hardships, is also against the evidence available on record. On the other hand, learned counsel representing the respondents has submitted that, in the facts and circumstances of the case, no interference by this court is warranted in the judgment rendered by the prescribed authority, which has been affirmed by the appellate court. He has also stated that, in absence of any provisions under UP Act number 13 of 1972 permitting cross examination of the witnesses, there is no illegality which can be said to have been committed by the prescribed authority in denying the said opportunity to the petitioners. Taking up the first argument raised by the learned counsel for the petitioners, I may only refer to the contents of the application made by the petitioners before the prescribed authority. The said application is on record. According to the said application, it was submitted by the petitioners before the prescribed authority that under the changed circumstances, the respondents have put wrong facts in respect of shop which is adjoining the premises in question and was earlier in the occupation of another tenant, Ram Raj Prajapati. It was further stated in the said application that earlier the learned prescribed authority had rejected the application for issuing commission, and as such it would be in the interest of justice that in respect of the fact deposed by the witnesses produced by the respondents, the petitioners may be permitted to cross examine them.